The jurors are actually walking in right now as we speak. We're going to go ahead and toss into the courtroom right now. We have audio from the courtroom. We're listening in that Oakland County Courthouse.
279990 FH, the People versus Jennifer Crumbley. There is an order restricting pretrial publicity. It was entered on July 14th, 2022. That order will be set aside as soon as the verdict is read, and will also be issuing an order that will obviously not be made public in the courthouse until tomorrow morning. In addition, case number 22279989 FH, the People versus James Crumbley, the same thing. The order restricting pretrial publicity was entered on July 14, 2022, and that order will also be set aside as of the reading of the verdict. Are you ready for the jury?
Yes, Your Honor.
Yes, Your Honor. All rise for the jury.
Good evening.
Good evening.
Be seated. Ladies and gentlemen, I know you've worked very hard, and we've all been waiting your decision. I know this was a very intense decision for you all to make. I believe you've selected a four-person. Who's it, four-person? You're the four-person. Could you read the verdict, please?
Each count?
Sure.
Count 1, involuntary manslaughter as to Madison Baldwin. Guilty of involuntary manslaughter as to Madison Baldwin. Count 2, involuntary manslaughter as to Tate Meir. Guilty of involuntary manslaughter as to Tate Meir. Count 3, involuntary manslaughter as to Hannah St. Juliana. Guilty of involuntary manslaughter as to Hannah St. Juliana. Count 4, involuntary manslaughter as to Justin Schilling. Guilty of involuntary manslaughter as to Justin Schilling.
Thank you, four-person. I'm going to ask Ms. Williams to poll the jury. So she's going to ask you each.
Jury in seat number 1, was that and is that your verdict?
It is.
Jury in seat number 2, was that and is that your verdict?
It is.
Jury in seat number 3, was that and is that your verdict?
It is.
Jury in seat number 4, was that and is that your verdict? It is. Jury in seat number 6, was that and is that your verdict? It is. Jury in seat number 7, was that and is that your verdict? It is. Jury in seat number 8, was that and is that your verdict?
It is.
Jury in seat number 9, was that and is that your verdict?
It is.
Jury in seat number 11, was that and is that your verdict? It is. Jury in seat number 12, was that and is that your verdict?
Yes, it is.
Jury in seat number 13, was that and is that your verdict?
It is.
Jury in seat number 14, was that and is that your verdict? It is.
Thank you, ladies and gentlemen. I know how hard this has been on all of you just by reading your face. I know this has been a very hard decision, and we appreciate your time. I'm going to ask you to return to the jury room, and I'll be there with you in a few minutes, all right?
All rise for the jury.
All right, you may be seated. Bond is rolled. Sentencing will be April 9th at 9 o'clock in the morning. All right. I'll allow both sides to speak to the jury if they're.
You've been watching court proceedings of James Crumbley being found guilty on all 4 counts of involuntary manslaughter. He is the father of Ethan Crumbley, who killed 4 students at Michigan's Oxford High School in 2021. James Crumbley's wife, Jennifer, was found guilty of the same 4 charges last month. CBS News legal contributor and Loyola Law School professor Jessica Levinson is with us, the hardest working analyst in the business. Jessica, what stood out most to you about this case?
Well, I think now that we have 2 guilty verdicts here, we can say that this is not just a one-off. Both parents have been found guilty of involuntary manslaughter, and I think this does potentially create a new avenue of liability. I hate to say it, but for the next one, because we know there will be a next one. There will be another school shooting. Now, there were facts in this case that were particularly bad for the parents and that indicated that they themselves had a duty, which they breached. That by failing to act, not just acting, by failing to act, there was a foreseeable consequence and that they could be held responsible for that consequence. It won't be that in every school shooting case that happens, that the parents had the same kind of red flags that we saw in this case, that there was the same kind of evidence of the text messages from their son saying, right, I just want help, I just need help. That both parents being called to school the day of the shooting, being shown a disturbing drawing with their son having drawn a gun and violence in that drawing. But I think we've now not just had the first, we've had the second, and I think we will potentially see prosecutors try this avenue again in other cases.
What do you think, as you mentioned, the facts of this case were, there were a lot of red flags really leading right up until almost the moment. Help us understand what the test might be in another case. Would it be something like, you know, a reasonable person's judgment about, assume there were some lesser number of flags, but still, you know, is it merely the obligation to lock up a gun that a child has access to? What would the test be maybe for this if it goes forward? Because as you say, this is going to happen again.
This is such a good question. And the standard here is gross negligence, not simple negligence. So it can't just be, I thought maybe something bad could happen. You really have to have seen and actively avoided a number of big red flags. And I hate to give you this answer, but we now have the first 2. So we have one set of facts to indicate this is enough. And we really don't have the spectrum of how much evidence do you need, because there just is no 0 to 60 here in the sense that we have one example and we don't know for the next one, again, what would weigh most heavily in the jurors' minds. I have to think that the fact that the parents were called to the school that morning for disturbing behavior, the fact that they purchased the gun, that they didn't secure the gun, that there were ongoing red flags about mental illness, all of those contributed to the jury's verdict here. I'm not answering your question because I don't know that we have an answer for how many of the red flags are we going to need the next time.
Right. You are, in fact, answering the question perfectly, which is that it's not knowable, and the definition of gross negligence will be determined more fully the more cases exist. Seems perfect to me. Jessica Levinson, thank you both. Thank you very much.
Thank you.